Hello, today we're going to continue a discussion of the survivor benefit plan in relation to a divorce in Wisconsin involving a military service member. In an earlier blog, we talked about what the survivor benefit plan is and what are the restrictions and costs for awarding that or not to the former spouse. But there is more to consider than just writing into a divorce judgment that the former spouse gets the survivor benefit plan, because that isn't the end of the story. The military and federal regulations require that the service member choose or elect, is the language that they use, elect the survivor benefit as per the divorce judgment. And there are deadlines for that. So the former spouse in particular must be acutely aware of those deadlines to ensure that they are not missed and his or her expected benefit is terminated. Because in some ways, largely, if these deadlines are missed, there's no way to go back and change it. So there are two deadlines which are somewhat confusing. The first is if the service member is cooperative, which we all hope he or she would be, and the order says that the former spouse is to get the survivor benefit, the service member should elect former spouse coverage by filing the proper military form, that's Form 2656. That form must be completed and filed within 1 year of the divorce judgment. Again, 1 year of the divorce judgment. That may not be the day the hearing was held. That may be a very different time. So make sure, as the former spouse, that you speak with your lawyer and set a deadline to get clarification and confirmation, actually, that the service member elected the former spouse coverage within the appropriate period of time. And in fact, if you're going to set a deadline, it should be set several months before the 1 year deadline. So if the member doesn't comply, you can get into court with perhaps a contempt motion or something else to get that form completed and filed within the deadline period. There is another option in case the service member is not cooperative, and that is to file a deemed election by the former spouse. What you need to do is file Form 2656-10 along with a certified copy of the order awarding the survivor benefit plan to the former spouse. The deadline for this is that it must be filed within 1 year of the order granting the survivor benefit plan. That is not necessarily the date of divorce. In some cases, an order for a qualified domestic relations order, which is usually the document that is drafted to divide a member's military retired pay, can be drafted at a time before the divorce judgment or afterwards. And the divorce judgment in this case has no practical effect in the sense of setting this deadline. So keep in mind that, again, the easiest thing for the former spouse to do is to not rely on the service member to file the appropriate document timely. Even the best of intentions can be forgotten, or there may be something that comes up that prevents the service member from following through. So the easiest thing to do for the former spouse is just to file Form 2656-10 along with a certified copy of the judgment and receive the confirmation from the military that they got the document and they've accepted it. That's another piece of the puzzle. The military has to accept the document. So My advice is for former spouses to make sure that both of these deadlines are clarified in any divorce judgment or qualified domestic relations order regarding the survivor plan. And if there's any question at all that the service member will comply with the demand to elect the former spouse coverage, go ahead and do it yourself. Because once these deadlines are missed, they are missed for good, and a benefit that you thought you were receiving can be lost forever. So again, both the former spouse and his or her lawyer should be well aware of these deadlines and make sure they are calendared so the significant benefit is not lost. Thank you. We'll talk soon.